Hi and welcome to the Kemp IT Law vlog. I'm Deirdre. In this vlog, we look briefly at the Metaverse. Despite how futuristic and interesting it sounds, the Metaverse, when it coalesces, will still be comprised of code and data, vast amounts of both. Will existing legal concepts of ownership and IP rights ultimately prove, to quote Altered Carbon, to be relevant only as data? Or will these concepts continue to live on and apply to and in the Metaverse? One aspect of this question concerns how the concepts of ownership and control of traditional IP rights will apply. Interestingly, we already know that many IP rights cannot be authored and owned by machines. Under Section 9(3) of the Copyright Designs and Patents Act in the UK, the author of a computer-generated literary, dramatic, musical or artistic work is the person who made the arrangements necessary for the creation of the work. Similarly, for patents, the UK Court of Appeal has recently confirmed that an AI machine is not an inventor for the purposes of the Act. The US District Court of the Eastern District of Virginia reached a similar conclusion recently. So what if my avatar uses my friendly Metaverse AI to write a book or create a painting in the Metaverse? Do I own it? Can I monetize it and sell it? Or does the IP belong to the tech companies behind the Metaverse? What if I own IP, say a trademark, in the real world and turn it into a virtual trademark? Do I still own that virtual trademark? These are thorny and interesting questions that in the main, as yet, courts have not grappled yet with. While a wait-and-see approach is one option, we don't recommend it. Instead, now's the time for content creators and IP holders to consider how best to protect their products, services and content when the existing walled gardens that will ultimately become the Metaverse coalesce. Solutions are being discussed, including, for example, using NFTs to designate ownership of virtual assets backed by blockchain technology, leveraging existing practice around granting and retaining rights in relation to user-generated content, and creating a virtualized legal system in the Metaverse. All of these, however, will fundamentally rely on a myriad of contractual terms to function effectively. It's therefore important for IP holders and content creators to start talking about what these contractual terms will look like for interoperability standards, for FRAND licensing terms for essential IP that underpins the Metaverse, how rights holders can contractually control, use and exploit their rights to protected works, what additional revenue streams can be generated based on Metaverse use cases, and what happens if those contractual terms are breached. We'll look at these issues more in upcoming blogs and vlogs. For more information, please see our website at www.kempitlaw.com. Thank you.